Mm. Good morning, everybody. This is Robert, the court coordinator. The judge will be taking the bench.
Thank you.
Good morning.
Morning.
Good morning.
Morning.
Honor.
How are you?
Morning.
I'm trying to get a full screen. Well, I can't see all my face, but in Ms. Dahlin and Ms. Pugh and Mr. Mattersdorf, but I can see enough of us. Thank you very much for your patience.
Bluetooth mode.
I only believe in excuses when I get them from other lawyers. So I apologize for starting late this morning.
It's fine.
Oh, I love hearing that. Thank you. Let me go down the docket and I'll take it in the docket order. Unless somebody has to go to federal court or something like that, you can let me know. All right. Oh, one last thing. Some of you may know, and some of you may not, and I know some of you are not here in El Paso, but I'm going to be retiring from the 168th District Court at the end of next year. And therefore, if you have a pending case that you want me to try, if you go to trial, then contact my court coordinator and I'll make arrangements to do that. I do have a bifurcated court. I have more criminal cases than civil. I have a lot of people in jail and they usually take precedence, but I'm going to be making extra efforts beginning next year in case anyone wants their case tried by me. Otherwise, I'm sure justice will be done by my successor. I don't know who that's going to be. All right. So thank you for that. Okay, Daddy-O's. Are we here again? Because we had this hearing. Is Daddy-O still here?
Your Honor, Scott Mann, for plaintiff Daddy-O's. If you recall, we had a hearing
Yes.
I don't know, about a week or two ago.
Right.
And then you wanted us all to wait until January
Yes.
yes, sir. And so I think Robert was going to take that case off today and reset it for January, where you could look at the motion for summary judgment as well,
right.
all at once.
In the limitations.
That's
argument.
it. That's it.
So I can strike you off this docket today?
Actually, I've got a case right after this,
Oh,
Judge.
okay.
I've got another.
All right. Well, I'm striking it off, and if there's anybody else here from Daddy-O's, you're excused. And then the next case I have is Melissa Ortega et al. Versus Patrick M. Davis. Christina Castle is they don't say plaintiff or defendant.
Plaintiff's lawyer, Your Honor, and I'm here on her behalf.
I'm sorry, who?
Rachel Verghese.
No, yes. Oh, I found you. Okay. And you're here. Now, are you representing the plaintiff?
Yes, Your Honor.
Okay. And then let me just get your name. Rachel.
Your Honor, Chris Borunda is here on behalf of Defendant Hernandez and Dr. Giles. I'm so sorry my voice is shot today.
I was going to say it did. I was surprised when I heard that voice and it said Chris Borunda. Yes, Miss Borunda, I saw you. So thank you very much. And I got you underneath here. So
Good morning, Your Honor. This is Leonard Lynch Jr. covering for Gerald Castillo and Amanda Stram for defendant El Paso Maternal Fetal Medicine East.
Okay. So this is a med-mal case.
Yes, Your Honor.
Okay. Yes, Your Honor.
Oh, I should have just looked at the year. I guess I would have guessed it was a med-mal. Anybody else on this case?
Judge,
yes, Your Honor.
Yeah, Yvonne Puig.
Yeah, this is my other one, Judge. Okay. I'm here for the hospital.
Okay.
Your Honor, this is Yvonne Puig, and I'm here for Dr. Patricia Davis and her PA, the BHS Physicians Network, Inc., and their DBAs, Health Partners and Advanced Center at Providence. It's nice to see you.
Likewise. I'm still looking for you on the screen, though.
I'm here. I see me, and I see you and everyone else. So I don't know.
All right. What is said is what counts most. Look, let me just tell you on these med-mal cases. This is an old case. Many of the ones that I have are old, and I don't know if they're that difficult that happens, or they just move very slowly. So understanding that and looking at all the parties involved, and now there's a motion to compel hearing. Let me just ask: has there been has this case gone to mediation?
No, Your Honor.
Okay.
And I just want to let you know, Judge, I apologize for the inconvenience of being here today. I've had some medical issues, and I was in the hospital a couple of weeks ago. I was in trial this week, and my the paralegal on this case told me that this was an oversight. She had started the responses to the request for production and didn't finish them. She served them this morning. I reached out to opposing counsel when I found out about this yesterday afternoon, and also twice this morning to let her know that we are filing them without objections this morning. So we have done that.
Is that the subject of this hearing?
Yes, Your Honor.
Okay.
Your Honor,
Yes.
if I may, this is my motion, and it's a two-part motion. Number one, with respect to the discovery responses, we were supposed to have a hearing on this issue back on July 31st.
Okay.
At plaintiff's request, we delayed it with the understanding that we would have a meeting or a discussion on August 15th in order to decide whether or not it was still necessary to proceed with the motion to compel. On the day that I called, the day that we were scheduled, plaintiff's counsel was not available, requested that we schedule another time the following Tuesday. When I made the call on Tuesday, plaintiff's counsel was once again not available. This discovery, they've had it since 2024. And there is a chain of correspondence where I've provided them with multiple extensions of time to provide these responses. I've reviewed what was filed this morning, and there's still a number of responses where it states that they will be supplemented, and that where we had requested authorizations, the authorizations have not been returned. I understand that there are circumstances beyond everyone's control. And I did see the email a moment ago requesting an additional week to complete this. And Your Honor, I'm very reasonable to deal with. I'm very easy to provide extensions. Again, there's a chain of emails where I've done that on this case. I'm fine that if the plaintiff represents to this court today that everything will be provided no later than the end of next week, fantastic. But that still leaves outstanding the issue of the plaintiff's deposition, who has not made herself very available in this case. And again, for a number of reasons, a number of explanations. It's a 2020 case involving facts that are 5 years old. There's multiple parties, and so scheduling is a challenge. This is the plaintiff's case, and she needs to make herself available for these depositions. But so far, we've not been able to do so. So we have got to get discovery going on this case to make a determination and properly advise our clients on the usefulness of a mediation on this case.
Okay.
So, Your Honor, I'm respectfully requesting that you issue an order that the plaintiff completely and fully provide the discovery responses in this case, including the authorizations, by the end of next week, as she requested, and that she provide multiple, more than 3 or 4, multiple dates for her deposition and be available without fail, without any further delay, so that we can get this case moving.
Okay, thank you. And fair enough to bring up, no, hold on, please.
Okay.
Fair enough to bring up, and let me take that up, okay, before I ask for responses. So there's a lot of lawyers involved, and not everybody is from El Paso. Some are from out of town. I don't hometown lawyers, so that's not an issue. But, you know, I've noticed that the El Paso bar is fairly tolerant and understanding. Maybe it's a number of lawyers that are involved that have made difficult that kind of interpersonal dialogue on this. But Ms. Vargas, without getting into why, I'd like to know what Ms. Borunda wants to know is like when well, I do have one question before that. The plaintiff and the deposition, the need to take the plaintiff to deposition. Does the plaintiff live in El Paso?
Let me see. Your Honor, the plaintiff is the deceased sister, so she's not going to be able to provide anything factually anyway.
Okay, hold on, Ms. Vargas.
Yes.
I can't accept surmising like that based on this. I'm trying to legally determine when this is going to get resolved. Like, for example, if you're the one deciding that she can't provide certain information, well, you know, let Ms. Borunda depose her and find out the way the law. Yes, go ahead.
I agree. I totally agree. I just wanted to make that clear. She does live in El Paso.
Okay.
And she's taking care of the twin daughters that were born.
Okay.
She's the plaintiff's mother, as has been represented to us before, that she is the plaintiff's mother.
Okay, well, whoever it is, is there a particular reason why somebody who's involved in a lawsuit can't take an hour or a couple of hours out of a day where you couldn't give the information or a date for anyone else who's interested in deposing her to have her available?
Your Honor, I apologize. I've not had this case for very long, and I will immediately get to working on it and make sure that that we provide dates for her deposition and that we provide authorizations and and then, you know, make sure that our responses are complete.
Okay, so Ms. Verghese, did I pronounce it correctly?
Verghese.
Verghese, I'm sorry. I'm asking sort of rhetorical questions, and you're saying, yes, I can do that. And any, well, not any, but a diligent lawyer could possibly get that done. But at this point, because we're in hearing on this, well, for example, Ms. Borunda, how soon would you want, you know, are we talking about early next year, or when would you want to have this deposition?
You know, realistically, Your Honor, and knowing some of the defense counsel involved in this case, I would say, if we get a date in January, if we get a date in December, we just need a date so that we can get this thing done and moving already. And so, yeah, it's going to be a challenge because of all the calendars involved. But if we have enough information and enough time to say, okay, this is the date, we'll make it happen.
Well, I'll sort of cut the baby in half because you even suggested that. But Ms. Verghese, can you give them dates that are going to be in the first half of January?
Yes, absolutely.
Okay. And then also, I don't know the level of negotiation that you've all permitted yourselves, but can you get with the other lawyers, or can someone, well, Ms. Borunda, you've been pretty astute about other people's, I would like for you to arrange with Ms. Borunda for the possible dates.
Okay.
Talk to her, please. And then I guess she has a better conduit to the lawyers that are in El Paso to see if it's convenient or not. And then I bet with 2 or 3 dates, maybe this deposition can be held.
Okay.
Does that take care of one of the issues on your motion to compel, Ms. Borunda?
That would take care of the deposition. And then, as I stated, if we could just get a ruling that they need to have the supplementation before the end of next week.
Well, wait, I want to deal with the second one. So
Okay.
Anybody else here? Is there anything else that you would suggest I do on this? And Ms. Borunda, are you satisfied with that?
Yes.
Okay. So with respect to the supplementation, how long do you think, Ms. Well, you know, you said you barely got on this case, and I don't know, your law firm, or maybe it got sent to you, but you know, you're familiar with how long it normally takes to get supplementation of these types of records. So how soon do you think, and don't cut yourself short and say, oh, I can do it by Friday, but how much time do you need to supplement the record? And then if you don't supplement certain parts and we're back here again, then I'll be asking you, why couldn't you do it during that amount of time and all? So just tell me what your estimate is.
I think we can for sure get the authorizations. If it's like things that, I don't know what Maria put in, I haven't had a chance to look at what she filed this morning. I told her to take out all of the any objections, and just answer. And
okay, so I know you're speaking generally. All I'm saying is, without the specificity, how much time do you need to be up to speed on this case, to be competent to predict or to get the supplementations that are needed based on your experience from providing those types of supplementations in these kind of circumstances?
Medical records can take longer.
I don't need an explanation.
Sure.
I want you to give me a time, please.
If I could have 30 days.
Okay. I'll give you 45.
Okay.
All right. Ms.
Thank you
Borunda,
so
does
much.
that satisfy or do I need to be more specific?
Well, in that case, I think in order to have all the documentation that we need to obtain through authorization, then we should probably look at depositions in February rather than January, because that's going to take us time once we get those signed authorizations.
If no one objects to that, I don't have a problem with you doing it in February, and that would only change my requests and rulings here to get with Ms. Verghese and pick dates in February.
Judge, I wanted to mention one thing.
Yes,
A
ma'am.
lot of times we get authorizations from defense counsel and they want everything under the sun, including HIV information, gynecology information that's not related to pregnancy, or this pregnancy. I think, especially in this political climate, I really,
Ma'am, may I interrupt you?
sure.
Okay. The case has been pending since 2020. Okay. If there's anything like that on there, file a motion to object and I'll hear it, or try and work it out amongst yourselves. Because I don't know if this is one of those cases where that was requested, and I'm not going to get into that right now with this kind of a docket, but file a motion to object and then we'll take it up. And then I would request that you file it promptly and not do it at leisure, so that we can get going with the rest of this stuff.
Okay, thank you, Your Honor.
And, I mean, Ms. Barunda already filed her motion to compel. And she's already, she didn't stick her neck out because she is that kind of lawyer but, she's already been bold in expressing her opinion here publicly. And I think we're on Zoom. So she's already done that. And so if you can't work something out with her, then file your motion, but do it promptly. I mean, it'll be not ironic. It would be disappointing if she has to file another one of these motions because you got around to doing that later. So I just would urge that. Okay. The other thing to let you know, my experience with these medical malpractice cases, and again, I'm not principally a civil judge lawyer, although I consider myself competent in doing that. It's not unusual for these cases to be this old, unfortunately, and not in my court at least. And yes, we all hit COVID, and there was a delay in that type of. But whenever you have this many lawyers, that means somebody's really serious about pursuing this, and I'm all for trying to get this done expeditiously at this point. And enough time has gone by to where the norm of an extended delay on a med mal, you're passing that now. Okay. Now it's a different matter. And I'm not just talking to you, Ms. Verghese, I'm talking to all the lawyers. Okay? So please, I'm not going to set motions for you, but they're easy to set in my court. I do Zoom, but if it is filed here in El Paso, I will take a reasonable request to do it in person and set an in-person hearing if I have to do that. Okay?
Thank you.
Yes, ma'am. Anybody else? Okay, anyone here on this case? Mr. Mann, if that's the only other case you have, you're excused, or don't tell me you got
Judge. Appreciate it.
Take care.
You too.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Yes, sir. All right. Let me see. Who's next? Oh,
Bye,
Ms.
Your Honor.
Labinati, what do you have? What do you have, Ms. Labinati?
Let me see, Judge. Your Honor, we have a motion for summary judgment hearing and continuance on that. I know I believe it says Andrew Armia, but I'm assuming Ms. Vasquez will be covering for Kurt Paxson. I'm not sure, right?
Where are the
Cindy?
parties? I can't get everybody down. Oh, here, maybe I need to hit okay.
Yes, Your Honor.
Okay, now I can see everybody.
Your Honor, I'm
Go ahead.
here on behalf of defendants Golardi Group Inc. and EP Franks 2016 LLC for Kurt Paxson, Your Honor.
Can you give me the last four of the case number?
Yes, Your Honor, 0724.
Okay. I'm sorry, and then you're here for Kurt Paxson, and repeat your name. Oh, Ms. Armijo.
No, Your Honor.
No,
Cindy
is that Richard
Vasquez.
Medersdorf's got that. Okay, who are you?
Cindy Vasquez, Your Honor.
Thank you. I was looking at the subtitle there.
Right, Your Honor. So they filed a motion to continue. We amended our petition and we added parties and new causes of action. I believe that it's ground for, I mean, I don't know. I was hoping that they withdraw this hearing because I don't know that the court can at this time. We have added new causes of actions against the defendant that they are saying are not proper parties. Now there are new causes of actions against those defendants who they allegedly say they're not proper parties. So pretty much in summary, Your Honor, I mean, we filed a detailed response with case law, but in summary, we filed a lawsuit against Gallardi Group and Hot Dogs and El Paso Franks LLC. They do agree El Paso Franks LLC is a proper party. So the motion for summary judgment is only limited to Gallardi Group. They're arguing that that is not a they are the franchisor. We did sue the DBA in this case. The DBA is Winner Schnitzel. So we had listed Gallardi Group Inc., DBA Winner Schnitzel. So we had the DBA listed already, and we had El Paso Franks LLC. And
okay, Ms. Labinati, may I interrupt you?
Sure.
Please, just 1 second. I mean, you said enough. I will exercise my discretion to allow some time for other motions or to be either updated or filed instead of me going over a motion for summary judgment that was based on older pleadings. Would that,
Your Honor, I
would
was
that be
hoping it
appropriate?
was canceled, but I guess I didn't get, you know what I mean? Because based on the amended pleading, I don't think this motion is even at this
No, well,
time.
I know, but I'm going to give them a hearing if they insist on it, or, if they don't want to. I mean, like when you said, Ms. Labinati, you are so experienced. When you said you were hoping they would drop it and all, I take it other lawyers might have, might not have. But whatever it is that the lawyers who are driving the motion exercise their sound discretion and also are probably desirous of a efficient process here. I am going to, I'm not going to hear that motion today. And then, and I'm going to allow response to Ms. Labinati's new pleadings or an amended motion stating that you took that into account in case I have to go over attorney's fees or anything like that. Is that satisfactory to everybody?
Yes, Your Honor. We were hoping to get it heard today precisely because the causes of action that Gallardi Group is seeking that the court dismiss there's no basis. In fact, the motion
Yes, Armijo. Yes, Armijo.
It's Miss.
Yeah, I know, but
I don't know why it's showing as Andrew Armijo.
Oh, I'm sorry. I'm sorry. It says Andrew Armijo, Miss Vasquez, and no. Look, I'm not hearing argument on that. I already told you that even if you don't get to nitpick, I can even refuse to hear a motion for summary judgment under the rules, as I understand it. I want to hear everybody, but I don't want to be doing it piecemeal on a big case like this. So all I'm saying is, regardless of what you think that maybe you should have had yours heard today, Ms. Labinati told me that there are new pleadings. And so when I want to hear the whole thing. So I respect your opinion, but I thought I moved past that.
I appreciate that, Your Honor. I just wanted to provide some context, but I appreciate the court's ruling.
Thank you. All right. So Ms. Labinati, since you're going to be the person having to respond, and then you're the one who brought up that there's been amended pleadings.
I will submit an order, Your Honor.
No, I know that, but also, if they're going to do well, I don't want this to be me cutting off their motion by summary judgment without them even acknowledging that that's what it would be.
But it can't, and there cannot be a motion for summary judgment, Your Honor, when we allege new claims against those individuals that are part of this case. So I disagree with Ms. Vasquez, and I have an attorney.
I haven't been able to state why we think the motion should be set for hearing today and be heard. So I don't know what.
Well, I mean, there is no basis because we filed new causes of action, and that gives us the opportunity to conduct discovery on those claims. And I feel very comfortable on those claims. I think you can file a motion for summary judgment on the new claims after discovery has occurred. But as the new amended pleading stands, I don't think it's even right at this point. And, the rules are very clear on that. So I did file an amended pleading, and unfortunately for your client's position at this time, it can be a motion for summary judgment heard when I have factual basis arguing that your client engaged in those actions, which is clear by the evidence in this case, and it's clear by the emails and the attachment I've submitted, and I've sued everybody. So right now, what we need to do, we need to conduct depositions on those new causes of actions, and after that's done, then the defendant obviously will have a right and to exercise, the rules to file another motion for summary judgment hearing on the new claims. And as far as, I mean, it's in a situation, Your Honor, of misnomer, of misidentification, that they told us they were the right party based on a communication with them. So even if they weren't the right party, we still have sued the DBA, which under the rules, Texas Rules of Procedure, that applies. We now sued the adjuster and the other parties involved, the franchisor, who told us in an communication in writing that the correct name of the entity is Gallardi Inc. DBA Winner Schnitzel, which we use that. So now we allege claims of frauds and misrepresentation and brought those. Those are new claims. Those are not part of this motion for summary judgment. So how can the court address claims dismissing a party when I have new causes of action against that party that are not even part of the motion for summary judgment, and there has not been any discovery on the new claims? So there's no argument today.
I want to be heard now, please. Okay, I'm not making any decisions as a matter of law or interpreting any of the rules. I am telling everybody that I'm exercising the discretion that I have, and I'm not going to hear that hearing now. And then also, if everybody's in El Paso, maybe I should just do a live hearing. It seems, that way everybody's there, and a lot of times when these discussions are needed, I just take a recess, and then you all can talk about,
Sure.
trying to accommodate the lawyers. So if anybody wants a live hearing, ask for that. If not, I'll continue to do the Zoom. I'm not hearing that motion right now. I'm not resetting it. If I did start to say one thing, I don't require a new motion copy to be filed if that's what you want to go on, but reset it. Okay? And I would like the resetting to be a resetting date to be by agreement of the parties. And if you can't agree, then I will decide for you. And we have a procedure there with my court coordinator that if you don't agree, he'll let me know. And then I guess I'll have a hearing on, a date to set the motion for summary judgment. Okay? Is everybody satisfied with that?
Yes, Your Honor. Thank you.
Thank you, Ms. Vasquez. Wait. Yeah, Ms. Vasquez, how it changed?
Yes, I don't know what was going on with the thumbnail, Your Honor. I also saw that.
Well, wait a
it
minute.
said
Hold on. Are you talking about your name?
Yes.
Oh, I thought you were commenting on Ms. Levinati's. Okay.
No. I was talking about how it showed up as Andrew Armijo. I don't know what happened, but I will defer to the court's ruling.
A few years ago in a adjoining county, they didn't have a problem with a name. The lawyer was appearing as a cat.
Yeah. That made news worldwide, Your Honor.
Well, he used to practice here in El Paso, and he would say, "Judge, I'm not a cat." It's almost as if it got rehearsed. You couldn't ask for anything better. But I'm glad that the name straightened out, Ms. Vasquez. Okay. Anyone else here on that case or that has anything to say on it?
No, Your Honor.
All right. Thank you.
Thank you.
Your Honor.
You're excused. All right. I have LDNV Funding LLC versus Natividad Garcia for a default hearing. Price waived, the lawyer on the docket.
Yes, Judge. William Adolphin on behalf of the plaintiff, LVNV.
Okay. And whose price waived?
That's a managing attorney in my law firm.
Oh, okay. So you're sitting here for the attorney of record is Price Wade, and you're sitting in for him.
Yes, Judge.
Okay, thank you. 817 used to be Fort Worth. No, 877. I don't even know what that is now. Okay. Anyways, well, where do you hail from right now?
Nigeria.
You're in Nigeria?
Yeah. Oh no! Oh, right now, no. I'm in Houston.
Oh,
I
okay.
said where I hail from.
No. Yeah. No. I'm not. I don't ask for questions like that. All right. So it's a default hearing, and so was there no answer at all?
There was no answer at all. Service was returned back in October of 24.
Okay, and then was there effective service?
Yes, Judge.
And when I ask that, what I mean is, was that person personally served, or was it Rule 106 service?
No, Judge, this was personal service on this one.
Okay. So on the breach of contract, what's the amount in controversy?
$1,681.80.
Okay. And then just the last thing, what are you asking for in attorney's fees?
Well, waiving attorney's fees, just asking for cost of courts.
Okay, so submit your default judgment to my court coordinator. If you already did it, sometimes they send it to the district clerk, and it goes to Never Never Land because they don't accept unsigned pleadings. Other jurisdictions do. So get with Robert, my court coordinator, submit it to him by email if you haven't already. Probably do it anyways. Since I'm telling you to do that right now, it should be pretty easy. And then if you don't get a response or a signature within a week, don't be shy to call to find out what happened.
Yes, Judge.
All right. Thank you. You're excused.
Oh, no, I have 3 more.
You got 3. Okay. Well, I'll take whichever ones you have. What's the next one? Oh, I see one here. LVNB funding versus Samuel Rosas.
Yes, Judge.
Okay. Same situation?
Same situation, but this was a 106 service.
And then what's the amount of controversy?
Amount of controversy is $2,937.03.
Okay, since it was 106, it got my signature of approval on it from my court. I'll go ahead and grant the default hearing, and then same procedure.
Yes,
I'll be perusing to see if there's any particular provisions that I'll call you back if I have a problem with any of the provisions. What's the last one, sir?
I have 2 more. I have Brian Gorby. Last 4 is 2796.
I don't have that on here. Give me the last 5.
Page 2, third one down, Judge.
Oh, page 2, third one down. 1, 2, 3. Oh, okay. I thought I already did one. 2796. Yes, sir. Okay, that's against Brian Gorby. And is it the same situation?
Same situation, Judge.
What's the amount of controversy?
$954.41.
All right. Go ahead and submit your judgment and the same spiel as I gave you on the other 2. Thank you, sir.
Yes.
You're excused and have a good day.
Oh, I have one last one.
Oh, you said 3.
I said 3 more. Yes, that was only.
Oh, Natividad Garcia, did I already do that one?
We did that one. I have Jessica Ruiz. It is 4133.
4133. Oh, okay.
Same. Oh, okay.
Yeah, no, go ahead.
Yes, same situation in this one, Judge. 106, no answer. Amount in controversy, $2,071.16.
Okay, same instructions.
Yes, Judge.
Thank you.
Thank you very much. You have a good day.
one. All right. Harley Davidson Credit Corp versus Jorge Padilla. Anybody
Yes, Your
here on
Honor,
that?
this is Catherine Dolan. Yes, Your Honor, Catherine Dolan on behalf of Harley Davidson Credit Corp.
Yes. Okay, ma'am. I see you on there. Your lips aren't moving, but I see you. I don't know what happened to the. Okay, now they are. No, I'm just saying on the
Okay.
Zoom.
Okay.
That's how I find people on Zoom. Okay, ma'am.
Okay.
A writ of sequestration. Explain that to me, please.
Yes, we're here requesting an ex parte writ. Our client has a security interest in the collateral valued between $17,000 and $22,000. There's been no payment prior to April of this year, and they've been unable to get in contact with the borrower, so we're just requesting a writ be issued.
Okay, and what you gave me the value, but what is it? What do you want to sequester?
It's a Harley Davidson Tri-Glide.
Hey, I'm sorry, I should have figured that out with a name. Okay.
I don't know if they
those
sell
are
anything else. Yeah.
those are fairly routine, and you probably do these all the time. Is there anything extraordinary that you are asking for in that, like attorney's fees or anything like that?
I believe we're asking for $1,000 in attorney's fees, which is not out of the ordinary.
For the proceeding? For the proceeding?
For everything, right? Yeah.
Well,
For the whole.
summarize to me the efforts that you made to retrieve the collateral without having to come to a hearing on it.
My understanding is they had a repo company try to get the Harley, and they were unable to either get its location or for whatever reason. Usually by the time we're here, defendants are aware and
okay, I'm going to take a look at your request, but send it in to Robert, and then if I have any questions about it, I'll get back with you.
Okay, yeah, we did email a proposed order and the
right. Well, just to be clear on what I'm explaining is, you don't get to ask for $1,000 just because you had to handle it. I need to hear a little bit about why it was necessary for you to take this judicial step where you could be awarded $1,000 attorney's fees. That's what I'm saying. But I'll take a look at the writ request and see what it says.
Okay.
Thank you. You're excused.
Thank you, Your Honor.
You don't have another one. Okay.
No, I don't.
Okay. Robert, pull that one for me when you get it, please. All right. Who's next? Whoa, I'm going down the docket. Ford Motor versus Roberto Perez, etc.
Good morning, Your Honor. This is Darren Hatch, and I'm representing the plaintiff, Ford Motor Credit Company.
Yes, sir. Oh, same thing, writ of sequestration.
It is.
What are you trying to sequester? I mean, obviously a Ford Motor, I don't know. Go ahead and tell me, please.
Yes, actually, it's a 2023 Ford Bronco. The Ford Credit financed the defendant, Mr. Rosano's purchase of this vehicle. Ford Credit has a security interest in it, obviously. Mr. Rosano is the buyer. The co-defendant, Ms. De Perez, she is Mr. Rosano's wife. She's been included in the lawsuit only for possession purposes because Ford Credit's agent determined that Ms. De Perez has possession of the vehicle. So our only claim against her is for possession of the vehicle and nothing else. But the contract has been in default since May of 2024. Ford Credit's agents have attempted to recover the vehicle. The agent discovered the vehicle at the Windcrest Drive address, and it was blocked in by another vehicle, so the agent couldn't get to it.
I'll find it. But what kind of attorney's fees are you requesting?
Your Honor, we're not asking for attorney's fees at this time.
Okay. All
right. Your Honor, real quick before I sign off, I suppose. When I was preparing for today's hearing, I noticed that in my petition there is a typo as to the year of the vehicle. The petition says 2018. It's actually a 2023. The copy of the contract that's attached to the petition as Exhibit A states that the vehicle is a 2023 and not a 2018. I just wanted to bring that to the court's attention.
But let me do this. Okay. Robert, can you print out the petition, please? Don't tell me it's 20 pages, Mr. Hatch.
No, I think it's 10.
10? Okay.
10 if you include the 10 if you include the exhibits. I think just the petition itself is 7.
No, just a petition.
Okay. Okay, it's 7 pages.
What I'm intending to do is to take this hearing where you're making that correction and on a record, this hearing, and I'll make the correction and initial under it.
Excellent. Thank you, Your Honor.
And make a note that that you asked for this correction. That way you don't have any problems.
Thank you.
While Robert's printing that out and with the indulgence of the other lawyers waiting. So I used to do collections when I got out of law school. As stable as the law is on that, I'm sure maybe a lot of it has changed in 40 years or so, but I hadn't seen so many writs of sequestration before. Was it easier for the locals or are the creditors did they determine it's just easier to just cut to the chase and if they can't get it that way, they're not writing it off and they're getting the writ? Or what's your observation from the industry?
Well, Your Honor, when I got out of law school, I started doing sequestrations and replevins, and this was back in 2004, and I'm still doing them. And it's probably 85% of my practice. And I've been busy as I can possibly be for the last 4 or 5 or 6 years. So it's generally a low cost way of getting collateral if all else fails.
Okay. Cut to the chase and don't waste any more time on it, and don't let it go to waste. Well, that makes sense.
Yep.
That makes sense. It's I'm a district court, but I guess it could have been filed in the county court of law here. Thank you. And they can handle big cases also. But that's what surprised me. I get the big ones, the $1 million ones, and then a writ.
Yes.
Okay. So on what page is the error?
It is on page 2.
Okay.
And it's paragraph number 6. And then, and you're talking about the petition or the order?
No, just the correction, so I can correct your pleadings.
Okay.
As a court.
Yes. On page 2, paragraph 6.
Yeah, it says 2018 Ford Bronco, and it should be 2023.
Right. And then, and then again on page 5, paragraph 23, it says 2018.
Hold on.
Sorry.
Let me corrected on petitioners open court notice. Okay. You can ask for a copy of what I'm going to file.
Excellent.
But I just circled 2018. I put 2023. I put my initials next to it, and I put corrected on petitioner's open court notice.
Okay.
Oh, I might as well put the date, right? 10/2?
It is October 2nd.
All right. Does that cover everything that you need?
And also in paragraph 23, and this is on page 5, the vehicle's described again and again with 2018. And for the record, Your Honor, I prepare my own pleadings, so I made this mistake and nobody else did. So this is on me.
Don't be hard on yourself if you're not perfect.
I'm far from it.
CF page 2, corrected. CF page 2. Okay, and anywhere else?
That's it. Other than the proposed order that I submitted.
Right. Oh, okay. You know what? You can do it by hand and initial, or retype it, and let me do a correct order.
If it's better for the court, I'd prefer just to submit a new order with the correct.
That's what I'm saying.
Yes.
Submit a new order with a corrected amount.
Okay, I'll do that.
And then Robert will be waiting for that, and that's what's going to get signed.
Okay, I'll do that.
Thank you.
All right, that's all I have, Your Honor.
All right, take care.
Thank you. Bye-bye.
Bye. We're going to take a 1 minute recess to transport this. Okay. The last one standing. Let me see. The next one is GECU versus Robert Soltis, etc.
Morning, Judge. This is Walker Croson on behalf of GECU.
How are you doing, Mr. Croson?
Good to see you, Judge.
Likewise. Okay. So it's a foreclosure.
This is a this is a home equity foreclosure, so it's under Rule 736 of the Rules of Civil Procedure. We filed it back in May. The underlying note was a March 2023 home equity note, $136,500. The respondents entered into the notes. As of today, I think they are 15 months behind. They have made payments in 15 months. When we filed the application, they were 11 months behind. So it's not a quick trigger. GECU gives a lot of time. And so that's why we filed it. On the home equity foreclosure process, this is in rem only. We're not asking for attorney's fees or money or damages. We just need an order from you authorizing us to foreclose.
What kind of service did you get?
The clerk, the county clerk, mailed service on May 28th, and that's what is required under the rule. And the respondent has 38 days from the date of mailing. So June 7th was the answer deadline. No answer has been filed to date.
All right. So I'll please submit it to Robert so that for my signature. And the statute's pretty clear on what you put in there. You don't have anything extra in there, right?
Correct, Judge. Just an order authorizing us to go forward with foreclosure.
I'll peruse it, but count on it getting signed within a week, and don't be shy if you don't get that response within that time.
Thank you, Your Honor.
Please send it right now, even if you already had. That way, I have confidence that my court coordinator got it on my order.
Perfect.
Thank you very much, Mr. Croson. Take care.
Good seeing you. Thank you. Bye-bye.
Okay. Manuel Enrique Avila versus Elsa Villarreal on a personal injury claim. Right?
Hi, yes, good morning, Judge. Alejandra Valdez here for Michael Alvarez.
Yes.
Good morning, Your Honor. Joshua Murphy here on behalf of defendant Villarreal.
Okay, let me see. I heard the voice, but I didn't. Oh, I see you. Well, wait. It's yeah, Mr. Murphy. I see you. Okay. So, summary judgment based on what and who filed it?
This is an entry of judgment, Judge. This case has been mediated and agreed to be settled since end of March. We've been waiting for lien information since then. We've provided them with notice or information informing us that Molina Healthcare had an interest in it. We requested the lien reduction and we've requested the release over several months. And we just haven't had any response, any type of information provided, and we can't issue those checks without that information and those documents, Judge.
So sort of in the nature, but not quite a motion to compel.
Correct, Judge. We've just been here on standby. We've had no responses. We requested a hearing, and at that last hearing, counsel requested that it get reset and sent correspondence to the court requesting the same and didn't include us. So that's why this hearing was reset to today's date to try to get that information so we can get this one off your docket.
Okay. Ms. Valdez, response, or is this not contested and it can get worked out?
Yes, Judge, we got news on Tuesday barely that the lien has now been completed. So we should get it wrapped up pretty soon.
Sounds good. Do I need to take any more argument or whatever?
No, Judge, I believe with that, and once that document is provided to us along with the release, we can send those checks and get that issued and the dismissal sent to the court.
Great. Okay. Well, I'll wait for any other motions if those are needed. Otherwise, submit the settlement to the court coordinator, and for me to sign off on whatever I need to sign off on. Okay? You're both
Thank you, Judge.
excused. Thank you.
Appreciate your
Bye.
time, Judge. Thank
Bye-bye.
you.
Patricia Langston versus Jorge Villegas.
Counter.
And Villegas Law Firm and El Rey Investments, etc. Counsel, please.
Gabriel Canto for Jorge Villegas and Villegas Law Firm. We filed a.
Okay, hold on 1 second, please. You said Gabriel Cantor?
Canto, C-A-N-T-O.
Canto, I'm sorry, okay. Today is Yom Kippur, and Cantor is a common Jewish name also. That's what I thought I heard, but these acoustics and electronic. Okay, and then is anybody here for the opposing side?
Richard Mattersdorf, I represent one third-party defendant and third-party plaintiff, Sarah Tiziana, T-I-Z-I-A-N-A, Jackson.
Okay, so she's not even in the style. I don't think.
Yeah, I would add, I am not ready if the court wants to.
Okay, is there anybody else here on this case?
Hello, Your Honor. Yes, Raymond Torres. I'm here for El Rey.
Okay, so Mr. Canto, since you were the first out of the gate, I guess sort of brief me what this is all about. This hearing and why we're all here.
My clients and El Rey, Mr. Torres's clients, are the movements on a summary judgment. You may recall this case. It's been going for a while. The core dispute was a legal malpractice dispute between my client, who's Jorge Villegas, an attorney, and a former client of his. That dispute stemmed from a home. That case was filed all the way back in 2000. In late 2023, my clients filed third-party claims against the plaintiff's siblings because they were they had ownership stake in the house that was at issue. The core dispute in this case has been resolved. The dispute between my clients and Patricia Langston has been resolved. We have non-suited the claims, the counterclaims against her, the claims against my client have been non-suited. All third-party claims have been non-suited. There remain two claims. My clients filed a third-party claim against Ms. Jackson. Ms. Jackson filed a third-party counterclaim. Those are the only claims that remain before the court. We filed a motion for summary judgment on the counterclaim on the issue of mootness. The claim filed by Ms. Jackson is a claim for a declaratory judgment. It was a 2024, July 19th, 2024, third-party petition for declaratory judgment. The sole finding that the Ms. Jackson was asking the judge to make the court to make there was seeking declaratory relief that the underlying transaction was void. The settlement that was reached voided that transaction. So the one issue that they seek has been rendered moot by the underlying settlement. And so there is no longer a legal dispute between there is no longer a valid petition for declaratory judgment by Ms. Jackson against my clients. And again, when I say my clients, I'm including El Rey, who's technically not my client, but was included as a movement. So the three movements are Jorge Villegas, individual as an attorney, his law firm Villegas Law Firm, and El Rey Real Estate LLC, which was the entity that owned the home for a time. That was a lot of information.
No, I appreciate that. Thank you. Let me ask Mr. Torres, as far as me trying to get a background on this, Do you have anything to add to that?
Your Honor, we do not have anything to add. We accept Mr. Canto's argument in its entirety.
Okay. And then Mr. Mattersdorf, you said you're not ready to proceed. Can I have a brief explanation of that, or are you as confused as I am? But no, I'm being facetious. I can't hear you, sir.
I'm sorry. I've only been doing this for 5 years, and I still mute myself.
Yeah.
Your Honor, yesterday, Mr. Canto filed, or anyway, the counsel for Villegas Law Firm filed or sent an exhibit to this court to support a legal fee demand. As Mr. Canto notes, my client's sole claim was declaratory. My client's sole claim was declaratory judgment.
Okay.
And the request was for attorney's fees. And of the exhibit submitted to the court, at least of what I received, there were 20 pages of itemized charges, and the first 17 and a half pages are completely redacted.
Okay.
And one of the grounds for asking the court to award legal fees is that I was not cooperative or constructive in resolving the matter without court intervention. And in the billing, there are emails, and I've only been able to look at this shortly before coming online for hearing. But some of the emails, I'd like time to prepare a briefing on this to make sure I get it right. Some of the emails that say, for example, email correspondence with me, Mattersdorf, regarding filing a motion for traditional summary judgment and seeking resolution. And I, again, was just able to look at a few. The ones that I looked at were emails between us and the court and your court coordinator scheduling the hearing or conferencing on scheduling the summary judgment hearing. Also, it's impossible from the, again, 17 and a half pages out of 20 redacted to see what portion of the charges dealt with my client's sole counterclaim from among all these defendants. There was no discovery other than the initial disclosures. And the
how much
investments.
Mr. Mattersdorf,
what's that?
How much are they asking for?
I'm sorry, I missed that.
How much are they asking for?
13,000.
That's not correct.
728.
Okay.
That's not correct.
All right, hold on.
Well, it's for one third party
hold
defendant.
on, stop, please. Okay. Stop. Is everybody in El Paso?
I'm in Dallas.
Everybody else is in El Paso?
No,
Okay.
Paso.
All right, I'm going to have a live hearing. Sir, you could send local counsel if you want regarding this matter. And the summary judgment is requesting attorney's fees of an amount. Is that what you're saying?
May I respond? Or
No, Mr. Villegas, I'm asking to Mr. Mattersdorf. In other words, where's the request being made? What kind of pleading?
Well, I can't tell. It looks like to me a lot of entries for one co-defendant.
No, okay. Yeah, I don't think you understood me. Mr. Rincon, excuse me, Mr. Torres, in what kind of pleading are the attorney's fees requested?
Your Honor, I have the third-party plaintiff's traditional motion for summary judgment that was filed by Mr. Canto that we joined in the motion. I see that there's a section requesting attorney's fees under the Texas Uniform Declaratory Judgment Act, since it's a DEC action, and the co-defendants are seeking affirmative relief through an MSJ.
I know. So how much?
I don't have that number, Your Honor.
It's not in the pleading?
It's not.
Is it in the pleading?
Especially since
I
you
don't,
joined.
yeah, I don't have a number in the pleadings. If I may address the attorney's
No, you may
fees
not,
issue.
sir. Don't address that, okay? I'm trying to control this hearing, and I'm not going to give you a ruling today, okay? So let me move expeditiously. The problem is that when you start addressing stuff, you start arguing against each other, and I'm not prepared to take argument on this, and then, you know, other stuff is said. So I'm going to do this in a control setting in a live hearing. So I'm asking, do any of the pleadings state the amount, or was the bill just attached? Now you can say yes or no, Mr. Canto. If you filed anything that stated an amount.
I did not.
Okay. And you, Mr. Torres, did you file anything that stated an amount?
Your Honor, as far as I'm aware, we've joined in with the pleading filed by Mr. Villegas, so don't think so.
Okay. Mr. Mattersdorf, have you filed the pleading stating an amount that you want for attorney's fees?
No, Your Honor.
Okay, so I'm going to set this for a hearing in January. That'll give you all plenty of time to go over any motions that you need to file, any briefs that you need to file to me regarding that. And then I guess my ruling is going to have to be based on the findings of fact. And, you know, I've already heard some of them, and some of them are argumentative. So I'll do that. In the alternative, in the meantime, if you would like to get together and discuss this, and for example, if Mr. Mattersdorf, with all the experience that he has, deems that an attorney's fee where his client has to pay it is merited, then he may try and negotiate that as well. But I think a lack of clarity makes a Zoom hearing on this very difficult. So I will set it at that time, and then you all can file whatever you're going to file. And then if any one of the three parties abandons that hearing and doesn't show up, I will take up attorney's fees for that failure. Okay? I think that's the best way for me to do that. I'm not going to draft an order. I think it's pretty clear what I want. File any other additional motions, and I'll see you all at an agreed to date in January, and it'll be live in my courtroom. It'll probably be in an afternoon where I don't have anything that follows after that, so that if it's an extended hearing, that's fine. If the parties resolve this through a written instrument, and you give me you agree to it before we have the hearing, I'll be happy to sign off on it. Okay? One of the problems, I'm just suggesting, because I didn't hear anything, but Mr. Mattersdorf, probably some of the blacked out may be attorney-client privilege, and I don't know, somebody needs to brief me on how I can hear on that. If it's attorney-client privilege that doesn't want to be divulged, then how am I supposed to figure out, you know, what kind of fee is owed for that? So I'm just saying that, number one. And number two, the recipient of the attorney's fee is going to be whom, Mr. Villas? Excuse me, Mr. Canto. Who are you collecting the attorney's fee for?
My client.
I can't hear you.
My client.
I'm sorry?
My client.
Okay, state your client's name, please.
Mr. Villegas, Jorge Villegas.
A lawyer here in town.
Yes.
Okay, he needs to be here to be a witness.
Okay.
Okay.
If I might speak for a moment.
Okay, go ahead.
So the attorney fee issue is apparently what caused confusion, and I would, had I all the opportunity, I would have waived my request for attorney's fees today.
Okay, good. Stop right there. If that's the case, I'll have this hearing again with a waived attorney's fee and expecting Mr. Mattersdorf, and I'll do it by Zoom. And since the attorney's fee won't be at issue, I'll take up any substantive motions that have been filed. Okay?
If I may add?
Pardon me?
If I may add one more point?
Okay, go ahead.
The reason that I submitted that invoice was specifically because no response was filed to my MSJ.
Mr. Canto, no, stop. It's settled. You're abandoning it. I'm not going to get into that, and I'm not going to hear information about the pettiness or whatever you attribute to either Mr. Torres or Mr. Mattersdorf. So don't add that. You dropped it. That's great. Okay? You can leave it in there and you don't have to file amended pleadings, but I will be reminded that you've dropped that and that we're taking up another matter. So if there is another matter to take up, and if it's already filed, as a result of this hearing, whoever the movement is, get a setting. Okay? If
So get a
everything else,
setting?
reset this, yes. I'm not going to do the work for you. You all get together as lawyers and determine. And then the way that my court coordinator does is when there's multiple lawyers, they will, I guess he'll give you alternate dates and maybe not even force you to talk to each other. And then we'll get a setting and I'll do this on another Zoom. Now, the last question, Mr. Mattisdorf, how much time do you need to be properly prepared for whatever's filed right now?
Well, my next step by tomorrow would be to get with Mr. Conto to see if he can unredact or give me more insight. If attorney, I want to see some kind of pleading that attorney's fees are dropped.
Okay, well, but you tell them or send them a memo
then,
saying, Mr. Mattisdorf, listen to me, please, okay? Listen to me, okay? I'm the judge and I'm going to drive this. You send him something in writing telling him this is to confirm that you're not pursuing the attorney's fees. Respond ASAP. If you're not, you don't get a response. That's good enough for me. And I don't know what other kind of proof you want, but that kind of proof is moot for me and for anything dealing with this. All right? Okay. So get another setting and I'll hear anything that's pending that can't be resolved by agreement. And then also, Mr. Mattisdorf, just because I'm being facetious, if anybody's ganging up on you, because two other, the Rincon law firm joined in it and also all that doesn't, I'm going to go by what the law is, okay? So I'm not going to be taking a tally of, you know, how many are going for it or against it or whatever. And I appreciate that Rincon, you know, I'm very familiar with their group and Mr. Torres very responsibly handled that they're just riding the boat and being very formal about saying they're joining, okay? And if you owe them a response to the summary judgment, file it, if that's what the rules require. But you do not need to address the attorney's fees in your response, because I'm already telling you, and whoever wants an order, send it to me, that attorney's fees are not an issue in this hearing.
Thank you, Your Honor.
Okay.
And thanks to the plaintiffs.
Yeah, well, all of you. All right, thank you. Everybody's excused, and thank you very much, and thank you. And I mean this seriously. I mean this seriously. I do appreciate all your professionalism. I do. You know, I was able to get down to what was going on and what the status was of how you were negotiating with each other and stuff, and I think I've solved it by my ruling. All right, we'll see in a couple of weeks or days or whenever you all file.
Thank you, Your Honor.
I do have somebody from the county attorney's office. Are you here on this case, sir?
Not on this case, Your Honor.
Oh, okay, I'll call yours right now. You all are excused, or you can be here on standby and watch what I do with the last case I think that I have. Go ahead, Mr. Romero.
Thank you.
Good morning, Judge Manny Romero for the county entities, and I believe the petitioner for the expunction is on.
Oh, on this expunction case. Okay. Who's I'm sorry, you say Zoom user, but who are you? Am I supposed to, if I don't recognize you and I'm supposed to apologize? Ma'am, who are you?
Hello, good afternoon, Judge. My name is Paloma Martinez.
Okay. And you're on you filed the petition for expunction.
Yes, sir, I did.
And if you ever appeared before me, I'm sorry that I didn't recognize you, okay?
I actually recognize you.
Martinez.
And Judge, if I may give you a quick little background, Miss Molina.
Wait, hold on, let me find it.
Yes.
Well, how's it styled? Or what's the last four? Oh, I see it. Page 3. I see it. 3652. Okay. Okay, go ahead, Mr. Romero, if you'd like to explain this to me, and of course, Ms. Martinez will have an opportunity to respond. Go ahead.
Yes, I haven't, Ms. Martinez and I have not spoken, but she has spoken with our paralegal. My understanding is she was going to be seeking a continuance of this matter. She filed a petition for expunction. We are opposed, but my understanding is she has filed a petition for non-disclosure, which is pending in the 171st. And I believe that's set for hearing later this month. And then based off of that, she would make a determination on how she wanted to proceed with this expunction petition.
Okay, I'm sorry, what is a non-disclosure? Oh, okay.
And
So
that
you're
would
doing excuse me, sir. I'm just trying to settle my own brain on this. You are filing a non-disclosure as far as what's on record that would be disclosed after a deferred, or is that the nature of it?
Ms. Martinez, that's my understanding what she's doing and what my review of her petition, that's exactly what she filed.
Okay.
Your Honor, so I filed a petition for an expungement on a case that I had from 20 years ago when I was 19, 20 years old. I'm 41 now. I had no recollection of the case being on my record at that point. Until now that I ran a background check on myself, I saw that it was on there. And all these years, I thought it was because it said dismissed, I thought it meant expunged, not on my record, but I had everything wrong. So it said there's a difference between a dismissed case and an expunged case. So I had it totally wrong. So I filed for an expungement, and the county attorney came back and said that they needed more time because they weren't ready for it. That's why they filed a continuance. But they said, let's go ahead and continue with this. They had told me that unfortunately, they wouldn't be able to expunge it because of the nature of the case that was on file. But I am coming to the court to see if you guys would be able to assist me in getting this expunged, being that it's, after so many years, and, just coming to you all for help. Because
okay. Are you a lawyer?
I'm not, sir. I'm representing
But you filed it pro se?
Yes, sir.
Okay. I've never done this before, but and I can explain why I would do this. Mr. Romero, I was the first assistant at the DA's office when Jose Rodriguez and Jaime Esparza divided duties. And normally a DA's office handles the expunctions, but the county attorney took them because they wanted to do the civil, and they did the right thing and gave up their criminal practice and prosecutions of misdemeanors. And so ever since then, the county attorney has handled expunctions responsibly, okay? And then expunctions are handled I don't know how many are filed, but I myself do not require any of the parties to show up for me to formalize it, except by my signature if they have an agreement. And so, a lot of times I got 2 or 3 expunctions on my docket, and the county attorney doesn't show up, and they don't need to show up. And they do a lot of stuff. Through negotiation. Okay, Ms. Martinez, you have a right to represent yourself, and but you also have a big vested interest in the outcome of this.
I do. I currently work for the state of Texas, Your Honor.
Wait, hold on. Okay, hold on. Now I need to I can't hear you clearly. So either you need to speak closer into the envelope, microphone, if that improves it, but you sound muffled to me, so I haven't heard everything that you've said, but go ahead.
No, I was just going to add that I currently work for the state of Texas. I've been with the state of Texas for about 11 years. And not even if the non-disclosure is filed, it's something that's just kind of hidden. I think for an expungement because this will completely delete it from my record, and it's gonna, if it appears on it, it's gonna hinder my job right now that I've had with the state for 11 years, and I'm a single parent and I have 3 kids, and
okay.
It's just,
All right, so look, we are a public. We're on YouTube. I don't know how many people are watching. Okay, so there's that kind of accountability. But I don't mind giving you an extension. I mean, I don't know who said it, but I don't mind, giving you an extension. Normally, a continuance is filed, but I would just suggest strongly that if you have so much writing on it, like your career, that you find a good lawyer to represent you, to talk to the county attorney, because I don't know what the merits are or aren't. Okay. But I don't know if you've talked to them, and I'm not interested in knowing if you've talked to them before today. But if you haven't, you missed an opportunity. A lawyer, like a prosecutor in the DA's office, or the county attorney standing in, they have a lot of discretion on whether they're going to pursue an expunction. And you might have valid reasons why the county attorney's office ought to take into account the amount of damage that this would do versus the amount of benefit that society would get from keeping your record public. Okay? And then it never even comes into my office if they exercise that discretion, and I can tell you I know that for a fact, okay? And I was a prosecutor for 20 years, that it is done and it is not prohibited. But hearing what you have to tell me, and I know you can get a court-appointed lawyer, even though you might need one, but you got so much writing on it. This continuance that I give you for this hearing, I'm happy to give it to you as much time as you need, but I hope you also use it to see if you would not, if you can afford or if you would want legal counsel on this case. And there's a lot of, okay, go ahead.
May I interrupt? Actually, the continuous was being requested by the county attorney. I actually wanted to just kind of come in here and just like settle it today. But the continuance was requested by the county attorney because they said that they weren't prepared for the hearing today. So they wanted an extension for a whole month from now, but they went ahead and do it. So the continuance, I wasn't the one who requested it.
Okay, so let me also explain to you, okay?
Yes, sir.
If they would have asked me for continuance, if I didn't give it to them and they weren't ready, I could make a ruling, but I don't do that. I would grant a continuance for, a reasonable reason. And then also, they should have filed the continuance. I don't know if they did. Did you?
No, Judge. Like I
And
said,
they might have. I'm only speculating, okay? They might have if you were a lawyer and didn't agree to it or whatever, but you all aren't even talking. So I can do one of two things. I can request that you go to mediation. It is a civil case. But normally, which means you would go to a mediator and you'd have to pay him, but he would, talk to both sides and see if he can come, that you all can make an agreement. But normally, I have to follow the rule of law. And some of the things that you are saying, I'd have to see everything, but it is possible that you may not, that they could legally say that you should not be given an expunction. That the letter of the law says this, but they have a lot of discretion. Okay? And that's why I'm telling you that if you work for the government, you have a very old conviction, you're very concerned about what's on your record, it might behoove you to get a lawyer, but you're entitled to represent yourself. And if you do, I'll know that I already told you all of this, and I have to rule on the rule of law. I am not the one with discretion to say, oh, I think that's a good excuse. And then Mr. Romero saying, Judge, the law says this. But I'm going to tell you another thing, okay? It wouldn't be wrong for Mr. Romero to call you right after this and talk to you and take a lot of this stuff into account. Now that he understands from my hearing that you don't have a lawyer and what your circumstances are, it wouldn't be wrong. But also he could say, well, I'm sorry, I can't help you. I'll see you in court. All right? So you want to be proactive like you were filing your own petitions and all. It doesn't cost you anything. Give him a call and ask to speak with him. And if he says, no, I'm sorry, I can't help you. Okay. He's got bosses. You can go up the chain to their supervisors. But if you're asking for them to exercise discretion where the law will not hold you into account for what you did 20 years ago by keeping it on your record, then I can't make my decision based on, we used to call it equity, but oh, that's a good reason. That's a good excuse. I'm not a good person to do that. A mediator would be. You would be if you talk to him. And it's possible that if he can't agree and you come back the next time, because they're going to be ready next time. All right. Just because they weren't ready today doesn't mean that they can't make their case. They're going to be ready next time. You could say, Judge, can you send us to mediation? Maybe a third party can. I've never done it on an expunction. So I don't know. I hope that information helps you. I'm going to grant the request for another time, but I'm going to ask that when Robert sets it, he's going to send an email out that these are the 3 days available, and I'll set it by agreement of the parties. And then if you can't agree, then I'll have a hearing on that, and I'll tell you, you need to be here, you need to be there.
Okay.
So I don't know if that helps. And I'm not supposed to give you legal advice, and I didn't. What I explained to you is how things work as a person who's representing yourself and is not a lawyer.
Yes, sir. So
Let me just tell you one last thing. Most of the good lawyers that do criminal law are very familiar with expunctions, have done them before, and would be competent to represent you for an expunction. And there's a lot of lawyers that it's easy to find out, to get names of good lawyers that do court-appointed cases or even criminal law. And then, go get the free sit-in with them. A lot of them will talk to you and they'll say, well, no, I don't think you can afford my fee, but, you get a chance to talk to them for, 20 minutes to see if they'll take your case or if they'll discount you or whatever. So you have enough initiative to file your motion and to be going through this non-disclosure petition. And you probably went to the law library to research, and that's fine. But for this final decision on the expunction and the concern about your reputation or your record that you've expressed and telling me who you work for, that's something you might want to think about, but I'm not telling you to do that. I'll be as fair to both sides if we have this hearing and I end up making a decision.
Okay, so just to recap, we're going to get some court dates on the hearing on a mediation.
My court coordinator, when you got the setting, he gave me his email, right?
Yes.
Okay, so he's going to send you an email and Mr. Romero or the county attorney an email telling them these are the 3 dates that I have for a petition for expunction. Which of the dates is convenient to you? Because it's going to be a live hearing. I'm not going to do it on Zoom. But you're here in El Paso, right?
Yes, sir, I am.
Yeah, so it'll be here in my courtroom, and then, we'll have the hearing.
Yes, sir.
So at the very least, that needs to be done if whoever wants it set. So actually, I'm going to order Mr. Romero, since he's the one requesting the extension, and I'm granting it to him. I'm having him take the initiative on resetting it so that you're not on standby waiting, wondering what you need to do next.
Okay, yes, sir.
He will be sending an email and copying you and sending it to my clerk saying, can we get a date? And then my clerk is going to say, I got these days available. And then you can say, I can do this one and this one, or I can't do either of those dates and times.
Okay.
Right? Okay.
Thank you.
Luck.
Thank you so much.
Judge, if I may, real quick, I apologize. I apologize that my understanding on the continuance request was wrong and that my representation to the court was wrong. I apologize. I'll do better next time. I thought she was requesting, but it turns out if it's us.
Okay. Right. It could have been your paralegal telling you. You need to talk to your paralegal.
Well, I'm sorry about that, Your Honor.
No. And it's, we handle that, almost on a routine basis, but your case is a little bit different because you're filing a pro se, and then you personally are trying to cover 2 different difficult writs, or like the non-disclosure and then the actual act. So yeah, the non-disclosure.
Who for an attorney, right? At this point.
well, you were, if it's a non-disclosure, that means you probably were never found guilty. But you did have a probation. So anyways, I wish you well. And then if you call Mr. Romero, I bet you he'll be the gentleman he's been here. And not only because I told him to be so, he's going to handle you're a constituent of the county attorney. So he's going to handle you and be respectful to you and explain to you what the situation is. And then you can go from there.
I have no doubt. Thank you, Mr. Romero. Would I be able to get your contact information just so I could follow up with you?
You will on the emails.
Oh,
okay? I don't do that on Zoom. When Robert sends that to you, Mr. Romero will probably say, I can be contacted at this phone number. When you see that, you can call.
Okay, perfect. Sounds good.
All right. Y'all take care and you're excused.
Thank you, Your Honor.
All right. Bye-bye. Let me see. I have Mr. Yanez and Fireflies.
Good morning, Your Honor.
Hey.
I'm back.
You were hiding.
Yes, sir.
What are we here on?
We have a bond forfeiture case for 915 bail bonds, and Mr. Zoc is on Zoom too.
Okay.
We've agreed to ask Your Honor to reset this matter so we can give Mr. Zoc an opportunity to review some dates of issuance of the warrant to see if we can resolve this matter.
Okay. So who's the one who's going to be asking for the next setting, just so that you each aren't waiting for each other? Unless you want to wait for each other and you want this to get old.
Judge, my office will, or the county attorney's office will request the next setting after talking to Mr. Yanez.
Okay. Sounds like you all are talking already. So you're excused. Thank you for your courtesies of letting me know. And then we'll just wait for to get the next setting, and I'll see you then.
Thank you, Your Honor.
Thank you, Judge.
All right.
Bye-bye.
Bye-bye.
That concludes the docket, Judge.
Thank you.